Hi guys, hey, this is just going to be a real short video lecture on the federal criminal discovery. And the reason I want to talk about that, separate from the other short video that that you might have just watched on discovery, statute of limitations, and so forth, is that this short overview deals strictly with the federal criminal discovery guidelines. And I want to talk about that because in our final project, one of the things you have to look at is discovery delay. Specifically, you have to determine whether or not the prosecution's requested discovery delay violates federal laws, and then you have to defend that response. So I wanted to give you just a quick overview on the federal discovery rules. In other words, when does a federal prosecutor have to turn over certain items that he or she plans to use for trial? And there are different rules for different states. And so since our scenario deals with the federal courts, as this is a federal crime, bank robbery, I just want to touch on that real quick so that you'll make sure you get the maximum number of points for this particular critical element, okay? So again, a quick overview on what is criminal discovery. And so discovery is a term used in the law, and it refers to the process by which parties in the litigation, and in our case, it'd be a defense attorney and the United States Assistant Attorney, where they obtain information from each other. And so as I discussed in a previous lecture on discovery, more or not nowadays, I guess it's more of a two-way street than maybe what our perception is of discovery and watching some old movies, okay? So criminal discovery is limited to materials that are intended to be used directly at trial, as well as evidence that materially exonerates the defendant. So for example, if I'm a defense attorney and I have evidence that materially exonerates my defendant, the client, then I have to share that with the prosecutor, and vice versa. If the prosecutor comes up with evidence that somehow shows that my client could not have committed the crime, then he or she is obligated to disclose that information to me. But again, it's the materials that you plan on using at trial, and that's what's subject to discovery rules. So the sources that govern federal discovery rules are Rule 16 of the Federal Rules of Criminal Procedure, which we'll talk about here shortly, and two Supreme Court cases that deal with discovery, and a piece of legislation that was passed called the Jencks Act. And we'll talk about each of these briefly, but I think the focus that I want you to focus on for purposes of our assignment would be Rule 16 of the Federal Rules of Criminal Procedure. So Rule 16 basically says that once a defendant makes a demand on the government, so once the defendant's attorney, so in our case, a bank robber, so once the bank robber's attorney makes a demand on the government, and that is to the prosecuting attorney, the government is required, so let's go back, the government is required to produce items such as the defendant's statements, defendant's criminal record, reports of any examination and tests, documents, or other physical objects it intends to introduce to trial, and more. So basically what they at least have to provide you with are the basic police reports. In our case, it's a bank robbery. So, we should at least be able to get access to the initial police reports, any subsequent reports that were made, probably the arrest reports that were made in the state in which they were arrested. So as an attorney, once you make a demand on the government for discovery, they are obligated to turn over certain types of information that they have. And a lot of times these documents are used in some point during the indictment process or something of that nature. So the documents are there. Sometimes, as I mentioned in my previous lecture, some documents may not show up until much later because maybe you're having specific lab tests done or blood splatter type analysis done, and those may take a while for them to get there. But the basic information in terms of the robbery, the arrest, those are all things that the government has access to shortly after a crime. So again, once a defendant makes a demand on the government is required to produce the items. So In our case, the prosecutor wants to delay discovery until after the continuance, and you can decide for yourself whether or not he violates the rule. I think it's pretty clear that once a demand has been made, you have to provide that information. You can't hold it as a bargaining chip, which he appears to be doing in this case. Rule 16 is reciprocal, and the same thing. If, for example, the defense has something, let's say, that exonerates their one of the clients in our bank robbery case, and they need to turn that over so the government can evaluate that and determine whether or not to move forward on a case against one of the bank robbers. So basically the rule is reciprocal. Okay, so pay attention to this. This is going to help you on that critical element dealing with discovery delay. The other two are Brady and Giglio. Basically, Brady says the government has a duty to produce exculpatory evidence to the defense. Usually this comes into place if, for example, a police officer who is going to be a key witness has some evidence that shows that the police officer has been less than truthful in some investigation, something to that effect, okay? That's called Brady. That's a Brady issue. So the government has a duty to produce exculpatory evidence to the defense, all right? In this case, we'll go back to it again. For example, if the defendant is suspected of murder, but the government has evidence that DNA tests conclude that the murder weapon does not match the defendant, the government must produce that evidence to the defendant. Again, those are exculpatory types of evidence, but it can also apply to your witnesses too. Okay, Brady can apply to your witnesses. But again, this is an example, and this is when that disclosure has to be made. You know, for our simple purposes in our case, we don't need to go into this. Again, I would focus more of my efforts on examining this particular Rule 16 of the Federal Criminal Procedure and determining whether or not you think that the federal attorney violated this rule by not wanting to disclose or hand over discovered material. Here, the United States Supreme Court extended Brady's rule to cover impeaching information. The government is required to disclose all information that tends to undermine the credibility of its witnesses. For example, if the government plans to call an agent to testify and the agent was previously disciplined, the government must produce the information about the disciplinary action to the defendant, especially if the actions of an agent go towards one's credibility. Okay. Finally, the Jencks Act. Under this law, a party calling a witness is required to produce any recorded statements of that witness pertaining to the witness's testimony. For example, if the government calls a victim to testify about an assault and it has a recording or report of a previous interview with the victim about the assault, it must produce the report or the recording of the defendant. So basically, you have to produce reports if you have reports or any type of audio or audio/video type recordings. All right, closing thoughts. Again, the discovery typically begins after the defendant has been arraigned. Court will often seek deadlines on when discovery is to be completed. So as we talk about this issue with the 4-month continuance, okay, the request to extend discoveries is going to delay things even further. So hopefully you realize that the U.S. Attorney has to at least provide some of the basic discovery material, because otherwise he appears to be in violation of Rule 16. Discovery is often an ongoing affair throughout the trial process, and I mentioned that in one of my the previous short lecture, because certain tests, for example, lab work, may not come back immediately, and so once those items are returned, then obviously it's subject to discovery. And discovery can add efficiency, effectiveness to the court process, plea bargain. In other words, once one side, for example, once the bank robbers' attorneys realize that the government has a pretty solid case on them for bank robbery, then it might promote plea bargaining. And you'll learn a lot of this through discovery after you read the reports, after you determine the actions of each of the defendants, and an array of things that take place. So discovery is important because it does add efficiency and effectiveness to the court process. All right. So again, go back and take a look at this here rule number 16, because I think that's going to be key for that particular little response to the critical element. Okay? Anyhow, I hope that helps. If you have any other questions, please don't hesitate to contact me. And I look forward to reading your final reports. Just remember as a final note to use the grading rubric as an outline, and I'll tell you why, because your final project has probably close to 15 critical elements that you have to address. And if you do not address one of the critical elements, then I have to zero out that score, and I don't want to do that. I want you guys to earn the maximum number of points as possible. So make sure when you're done with your paper, you get out your the grading rubric and the assignment guidelines and overview, and you go through to make sure you address each of those critical elements. Also remember that unlike the milestones, the final project has an exemplary rating. So you not only have to provide the necessary proficient information, but to get the exemplary rating, sometimes you have to write or explain something in a exceptionally clear and contextualized way, or you have to provide me with some specific instances, some concrete examples, things like that. All right, so please take the time to review the grading rubric, the final project guidelines and rubric together, and make sure you address each of those carefully, each of these critical elements carefully. All right, in the meantime, if you have any other questions, please don't hesitate to contact me. Thanks a lot, guys, and have a good week.